Welcome back, everyone. My name is Andrew. I'm the founder and owner of IBIS Prep, and we are here today, the first class of 2025 for the Florida bar exam course, and we're gonna revisit con law. We had a con law workshop before Christmas break, but as many people know, sometimes Santa brings too much eggnog and we forget. And so we're going to revisit some of the important things, not just from con law, but I'm going to tap back into contracts and torts quickly just to, get the juices flowing. And then we'll get into specific essays and really feel confident. I guess I gotta share my password with everyone. You guys can guess what my password is.
Hashtag Canes.
Biscuit.
Trust fund.
Something like that. So you guys can all see my screen now. All right, cool. Sorry about that. So the things that from the first workshop, the things that I think are the most important, and if you can do this, it's been a proven method to pass, are memorizing the questionnaires, right? So like you can articulate these things, you can pass. What is a contract? A contract is an agreement between two or more parties in which there are valid remedies at law. Some contracts fall under the UCC, some fall under common law. The UCC is for goods, which are all things movable, and common law is for land, services, pretty much anything that's not considered a good, right? What's the difference between unilateral and a bilateral contract? Unilateral contract can be accepted by performance. A bilateral contract necessitates contract formation, offer, acceptance, and consideration. Offer is a manifestation of an intent to be bound by the terms of the contract that give the power of acceptance in the offeree, and an acceptance is a manifestation of intent to be bound by the terms of the contract. There needs to be mutual assent, meeting of the minds, and as we said, an intention to be bound by the terms. An advertisement can constitute an offer if it's very detailed in terms of how to accept, when, where, how much, right? If it's very detailed in manner, then an advertisement could constitute an offer. What is an advertisement usually?
An invitation to bargain.
Yeah, an invitation to deal, exactly. Okay, and then while we're on this now, what is a consideration?
A bargain for exchange. So detriment has to induce the benefit and the benefit has to induce the detriment.
Exactly, like a bargain for exchange of mutual detriment or value. Okay, what special rules apply to merchants? This is a really tough question. So far so good. Does everyone feel good about the first, 8 pieces? Like that's like coming on every single contracts essay. The issue is whether there's a contract. In order for it to be a contract, we need to determine if it's UCC versus common law, UCC for goods, all things movable, common law for services or land, maybe consider the predominant purpose test, things like that. But offer, acceptance, consideration. That's like contracts 101. That's your favorite bar tutor or professor. That's what they'll spend 10 years teaching you, but that's just the fundamentals, right? Everyone good with those fundamentals? Okay. And then we have special rules that apply to merchants. So those rules would be like the written confirmatory memo rule. So you'll see if there's like an oral agreement that should conform with the statute of frauds, but it doesn't, but then they later send like a memo or an email or some writing that has the terms, the essential terms, then that would be okay. Grace is saying the perfect tender rule. So yeah, that's fair enough. Under the UCC, there has to be perfect tender, meaning there can't be a non-conforming shipment. There needs to be the exact amount and the exact description. The firm offer rule is a rule that applies to merchants. So usually if you have an options contract to remain open, you don't need, you would need consideration, but between merchants, there's no need for consideration as long as there's a written firm offer. Yeah, so Grace is also saying no consideration for modifications is true. So modifications is something that a lot of people miss on contracts essays. The bow the forms provision, that's interesting too, like a counter offer or an acceptance that has an additional term under the UCC will be considered an acceptance, and the additional term will be part of the contract, so long as it's not material and does not materially alter the contract. So yeah, that's good. Bow the forms provision. Some of these important things that apply to merchants are important. And at the beginning of an essay, you want to identify, like, are the parties merchants? What type of contract is it? Is it an installment contract, a divisible contract, an options contract? Right, like, let's just get familiar, like, what type of contract is it? Who are the parties to the contract? And have we formed a contract? So, mirror image rule is under common law, where the offer and the acceptance must match exactly. Bow the forms we just talked about in the UCC, there could be an additional term so long as it's not material. And then perfect tender is delivery under the UCC must have perfect tender. Under common law, we just need substantial performance. Statute of frauds, what types of contracts does it apply to? Remember, my legs, contracts for marriage, contracts that cannot be completed within a year, contracts for land, executorships, goods over $500, and suretyships. And then when is it possible to overcome a statute of frauds defense? We consider the mnemonic swap, specially manufactured goods, written confirmatory memo, admission in court, promissory estoppel, and partial performance. That's like a really good place to get points on a contracts essay. Don't just tell them, statute of frauds, but also tell them exceptions to statute of frauds. I found that in your essays, people missed on modification and promissory estoppel quite a bit. Mutual and unilateral mistake. Mutual mistake is, it leads to rescission or reformation. There was no meeting of the minds. Unilateral mistake, one party made a mistake, and depending whether the other party knew of the mistaken party's mistake, they will have to bear the burden of that unilateral mistake. In class on Thursday, someone said that they remember eyes when they're thinking about, like, in common law, we'll talk about this today, intermediate scrutiny. They're like, intermediate scrutiny has to be related to an important government interest, like substantially related to important government interest. Intermediate, important. And then I said, I like eyes because in contracts, I remember there's a lot of eyes for defenses to formation and execution. Can anyone think of any defenses to formation or execution that start with I?
Intoxication,
That's the first one that came to your mind?
Infancy,
Infancy, yeah. Infancy, intoxication, incapacity, right? Incapacity is kind of includes intoxication and infancy if you think about it. What about to execution? Yeah, impracticability, impossibility, illegality, illusory contracts, right? These are some contracts that start with I. So, I mean, defense is a contract that start I. So, like, for all of you who signed into the class today, the password was parrot, right? Because I think that that's how you pass this test, by turning yourself into a parrot, just remembering all of the buzzwords that are associated with the different topics and reciting them on test day. I love essays compared to multiple choice because essays, you can just get points, it's like you can just reach for points and potentially get them. Multiple choice, you can know 95% of the material, but get it wrong because D included the other 5% and you get 0 points. So essays are a great opportunity for you to really demonstrate your knowledge. So, so we talked about defenses with eyes, we talked about statute of frauds. There's also mistake, fraud, duress, unconscionability, like procedural or substantive, frustration of purpose. There's a lot of different defenses that we could think of, and the more you could talk about on test day, I think the better. So misrepresentation and fraud are the same. Not really, because there's fraud in the factum and fraud in the inducement. Misrepresentation, I mean, there's concealment, there's failure to disclose. They're related, and it's kind of complicated because they can be torts, crimes, contract claims. So, like, those words I would say are related, but not exactly the same. Without getting into too much detail, I'll give you the simplest version. If you're writing an essay and you write about fraud, also write about misrepresentation, right? Like you might as well try to get more points from more buzzwords. Okay. So material and immaterial breach, a material breach deprives a party of the major rights of the contract, right? It strikes at the heart of the contract. Immaterial is minor. Equitable and legal relief. So legal is monetary. Equitable is court-ordered relief. What are all the different types of relief under contract defense? Anyone feel like they can answer this question confidently? You should all be confident by now.
Expectation damages.
Consequential, incidental.
Yeah. You cracked me up, Matt. Because I think anyone answer this question confidently said all the types of relief and you named one of them.
Well, you know,
Okay, so legal relief, expectation, consequential, incidental. That's a good start. What are some other types of legal relief, monetary relief?
Loss of wages, future income. No,
Yeah, lost
future income,
wages.
no.
I mean, I'd say lost wages, lost profits. Under the modern prevailing view, you can recover for lost profits. So lost wages, lost profits.
Oh, expectation damages? Did we say that?
Yeah, we said expectation, consequential, incidental. Expectation to recover, to put the non-breaching party in the position they'd be in if the contract was performed. Consequential are recoverable if they were foreseeable in the event of a breach, and then incidental damages are recoverable, you know, for mitigation or for trying to put yourself in a better position after the breach.
and then if it was reasonable, then liquidated damages could be there.
Liquidated damages are true. So if they're if they're reasonable, they do not operate as a penalty. They're typically limited to 20% of the contract price in Florida. So if you see a contract where it's like for widgets and then for a breach, it's going to be 50% of the widgets, oh, well, that would be a liquidated damages clause that would probably not be valid because it was unreasonable. So liquidated damages are put in the contract to contemplate damages ahead of time because they'd be too speculative in light of a breach. Solid work. What about, I would argue that restitution is a form of legal relief. It kind of straddles between legal and equitable because the court is ordering, you know, maybe through a quasi contract or some form, one party to act, but they're also ordering that party typically to pay money. So that's what could make it legal. We talked about reliance damages when they're related to like promissory estoppel. So promissory estoppel again could be an equitable form of relief, but like the actual reliance damages that are paid, we would consider legal relief, like monetary relief. Nominal damages, I mean that's in name only, very small, like a small amount of damages. Yeah, those are different forms of legal relief. And then equitable relief. What are some different forms of equitable relief?
Preliminary injunction.
Specific performance.
Yeah, injunction, specific performance for sure. Any others? Reformation, rescission.
Quasi-contract.
Yeah, quasi contract, which is like a court ordered contract, a contract that doesn't really exist, a fictitious contract. Like, think of a quasi contract and restitution to pay back a deposit when the event gets canceled. There's no real contract to pay back the deposit. I never signed that, but the court's going to order you pay back the deposit. That would be called a quasi contract. Yeah, pretty solid. Okay, so what are the requirements of a non-compete agreement? They have to be reasonable in subject matter, geographic scope, and duration. These are interesting, different types of contract, like an options contract. That means it stays open. You need consideration unless it's between merchants and it's a firm offer. A requirements contracts means that they'll purchase they agree to supply all that's needed. And then an output contract means they'll purchase all that is produced. And then installment contract, you know, delivery occurs sequentially. And it's important to note about installment contract that a one-time breach won't be material because there's an opportunity to cure potentially in a subsequent installment. firm offer rule between merchants, it's in writing, it'll remain open for up to 90 days. After that, it becomes revocable. The mailbox rule, offers are effective upon receipt, whereas acceptances are effective upon dispatch. We talked about liquidated damages contemplated ahead of time, written into the contract. So look out for that. If they make an agreement and say, in the event of a breach, this is what will be the remedy, that's a liquidated damages clause. It's meaning like we're contemplating it ahead of time. And it has to be reasonable, cannot operate as a penalty. What does that mean? A penalty? It means it's like the purpose of it can't be just to punish them. It has to be to truly remedy the other party. Anticipatory repudiation. So when one party unequivocally demonstrates an intent not to honor the obligations of a contract, right? It has to be clear and unequivocal. And then a request for further assurances is, an ask for assurances that there won't be a failure to perform. And merchants have 30 days to respond to that under the UCC. Parole evidence rule means that we're not going to allow extraneous evidence or oral evidence or outside evidence to contradict a fully integrated contract, like a contract that is, the four corners of the contract are meant to determine what's on the contract. Meaning like, hey, we were talking about $20, $30, but we wrote down $50, so we're going with $50. Now there are some exceptions to parole evidence. Does anyone know what some of the exceptions are to the parole evidence rule? Yeah, me neither.
Isn't one of them to show, for example, like trade usage or how they've like gone about the contract before?
For sure. Customer trade usage, I like that. What else?
Is one of them to clear mistakes, like misunderstandings?
I
To
thought you
sh-
were playing Jeopardy. Every answer is a question. Yeah, to clarify a mistake or ambiguity or defect information. I like what Sam Yates is saying, to show a condition. That's a heavily tested one, like a condition. Like, if the Dolphins make it to the Super Bowl, I think they still have a really small chance. Then I'll buy you tickets, right? So weeks later, Super Bowl comes up and it's the Chiefs versus the Eagles. And Tommy's like, "Oh, Andrew, you said you'd buy me Super Bowl tickets." I was like, "Hold up. If the Dolphins made it, there was a condition. We're allowed to bring in that condition." Yeah, so defect information, condition, clarify ambiguous terms, customer trade usage, to show an additional term, right? Like you said you would also provide a limo driver to the game, right? That's an additional term. It's not conflicting term, it's an additional term. So pretty solid work. And then any other topics or any other thoughts people have about contracts? Any other questions we have? I don't want to like close the book on contracts, but kind of, until close to the test, right? Any other questions anyone has about contracts for me? Contracts is a super manageable subject. That's why I start with it. Contracts are agreements. They should be in writing. You should talk about statute of frauds. You should talk about defenses. Remember the mnemonic: buy friends drinks, big drinks, body of law, formation, defenses, breach, damages. Pretty solid work. All right, let's talk about torts a little bit. I think torts is even easier to get through the questionnaire. All right, someone just needs to name them. Can someone confidently name all the intentional torts in Florida?
Assault, battery, false imprisonment, trespass to chattel, conversion, IIED, wrongful death. That's what I have.
I mean, wrongful death, I could argue could also be negligent, but the main ones you got for sure: assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, IIED, intentional interference with a business relationship. That's another big one, interference, right? I mean, there's other things you could argue for, like intentional anything, intentional endangerment, maybe malicious prosecution, some intentional elements of privacy torts and defamation of a public figure potentially. But yeah, those are the main ones: assault, battery, false imprisonment, trespass to land, trespass to shadows, conversion, IIED, and intentional interference with a business relationship. You all feel pretty confident? You can rattle that off? Cool. Transfer intent doctrine. So that means like you can transfer tort to tort, or you can transfer person to person. So if, Tommy intends to punch Johnny, Johnny ducks it, and then Tommy hits Susie, well, Susie will be able to prevail, saying that Tommy had the requisite intent to form assault and battery, even though it was intended to be on Johnny and not Susie. Also, it could be, so that's person to person. It could also be tort to tort. Let's say I only intended to assault. Well, let's not make it me. Let's say Johnny only intended to assault Tommy, but then Johnny actually landed the punch. He didn't intend to perform battery, but he intended to commit assault. So the intention will transfer from the tort of assault to the tort of battery. That's transferred intent. Elements of negligence, so duty, breach, causation, damages. Causation, talk about but for, actual cause, and then talk about proximate cause, the foreseeable plaintiff, the zone of danger. One thing I noticed that, when I grade your essays, it gets kind of repetitive. That's why I try to wait until y'all submit them so I can just do them back to back. But like, it's pretty repetitive. You guys all miss the same things. One thing that everyone missed in torts is the discussion of intervening versus supervening causes or events. Does anyone know the difference between those two?
Supervening cause, a supervening cause will cut off liability, intervening cause will not.
Exactly. So supervening will totally cut off liability. It'll lead to indemnity. Whereas intervening doesn't totally cut off liability. It'll lead to contribution. Does that make sense to everyone? Big words, right? Contribution, indemnity. Okay. Duty, breach, causation, damages, different types of negligence, negligent hiring, negligent entrustment, negligent supervision, negligent design, negligent manufacture, negligent anything, right? Just someone deviated from the standard of care. It's just really, you have to talk about negligence. Just like I say, you're always going to talk about statute of frauds on every contracts essay. I think you're going to talk about negligence on every torts essay. You can always contemporaneously argue that they were negligent. They deviated from the standard of care. Some defenses to negligence in Florida. We could argue maybe the statute of limitations has passed. It's been reduced to 2 years for negligence claims. We could argue that there was no duty. I mean, like that they didn't really owe a duty. What other defenses to negligence can people think of?
Consent,
I feel like consent is more of a defense to an intentional
like
tort.
intentional, that's true, sorry.
Yeah, but that's fair enough. I mean, oh, you know what would be a good one?
Assumption of risk.
Yeah, I guess assumption of risk. Yeah, I mean, it's consumption of risk and consent are solid defenses to torts in general. So is statute of limitations, and then another one could be like claim preclusion, right? Like res judicata, like the claim was already brought. Okay, fair enough. So what is negligence per se? That's like statutory negligence. That means that like there's a statute that defines a duty of care, like a speeding limit, right? 50 miles per hour. If you're going 60, you were pretty much negligent. Res ipsa loquitur, the thing speaks for itself. The plant falls off the balcony. Well, you were the owner of the balcony, or in exclusive control of the injury causing instrumentality, or the scalpel was left inside of the body. Well, the doctors were the exclusive controllers of the scalpel, and it wouldn't have ended up in the body in the absence of negligence. Premise liability. So premise liability pretty heavily tested. Premise liability comes down to like duty, breach, causation, damages. And you have to determine what duty was owed, and what duty is owed depends on the status of the person who was injured. Were they an invitee, licensee, known trespasser, unknown trespasser? And there's, that's kind of like invitee has the highest duty of care, unknown trespasser has the lowest duty of care. Florida is pretty complicated on this. Licensees, invitees, I would recommend just talking about them separately, but you could note that Florida may recognize something known as a invited licensee, which is kind of like a hybrid between the two. What duties are owed to known trespassers? So, you know, you still have a duty to not cause harm or to, you know, make safe dangerous conditions or to warn them. You know, if you know people are walking through your backyard, you can't just shoot guns in your backyard and be like, oh, they were trespassing. What is an eggshell plaintiff rule? Is like you take the plaintiff as you find them. If you know they're like Humpty Dumpty and they fall off and you push them and they break in half, well, you have to pay for them to get put back together again. These next questions are important. This has changed. So when you're looking at practice essays or you're watching lectures from, you know, that have been recorded and they talk about this, it has changed recently. Florida is now a modified comparative fault jurisdiction instead of a pure comparative fault jurisdiction, which means that if a plaintiff is over 50% at fault, they're barred from recovery. Florida does not recognize joint and several liability, it's abolished joint and several liability, so you have to go after each person individually. Defamation is when someone disseminates material to a third party that is injurious to another's reputation. Public and private. Public, you have to show actual malice, where if they're a private plaintiff, you just have to show mere negligence. Slander per se, the mnemonic I remember is club. These are where, you know, damages are presumed, so you don't even have to really show that it injured their reputation. It's just kind of presumed that it did and they were damaged. Would be like crimes of moral turpitude, you know, accusing someone of being a thief. A loathsome disease, accusing someone of having, you know, whatever they got up there in Tallahassee. That was a football joke, don't take it seriously. Unchastity, right? Accusing someone of being promiscuous. And then a business, you know, speaking about someone's business affairs. Those are all subject to slander per se. Invasion of privacy torts, you know, the mnemonic that I was taught was IFLAP, intrusion upon seclusion, false light, appropriation, and public disclosure of private facts. But Florida does not recognize a separate tort for false light. That's pretty much included in defamation. So what is subject to strict liability? You could have a strict liability products liability case. You could argue for inherently dangerous activities or wild animals, right? And then what are the elements of products liability case? So this means you know, commercial supplier, distributor, producer, manufacturer, retailer, wholesaler placed a defective product in the stream of commerce. And you could argue a design defect, you know, it failed the risk utility balancing test in the way it was designed. You could argue a manufacturing defect, meaning it wasn't created as it was designed, it came off the line differently. You could argue for a failure to warn or inadequate warning, the express warranty theories, or you could argue under the implied warranties of merchantability and fitness for a particular purpose. Merchantability, that the product didn't work, or fitness for a particular purpose, it didn't work for a particular function in which it was warranted to work for. Whenever you talk about products liability, strict liability, also argue negligence. Alternatively, Tommy could argue that it was negligent to design the product with spiky spikes. They had a duty to design a safe product. They deviated from this duty by designing it spiky. It caused injuries and there were damages, right? So those are two separate theories that could lead to recovery for the plaintiff.
Are dangerous instrumentalities, sorry, Andrew, dangerous instrumentalities, are those strict liability as well, or is that something that just like falls under like vicarious liability?
Yeah, it could be a vicarious liability and the dangerous instrumentality doctrine in Florida, which holds that you can be liable for injury that occurs when someone else is operating a dangerous instrumentality that you own, typically a car. So yeah, Florida does recommend.
Yeah, but it's not a strict liability thing, right? Like that doesn't fall under like abnormally dangerous activities.
No, not if it's, if Tommy uses my car and hits someone, I'm not gonna be held strictly liable for the injuries, but I could be held vicariously liable under the dangerous instrumentality doctrine. Strict liability is inherently dangerous activity. You could on the essay kind of have an argument about what constitutes an inherently dangerous activity. I mean, I think a good argument, I remember it was a UBE essay, was about fireworks. I mean, I argued that it wasn't inherently dangerous. Fireworks, people play with fireworks all the time. But like, Jason Pierre-Paul, the New York Giants guy, and then every year you see someone blowing their hand up, like maybe there is some danger but I don't think so. Another one is like guns, right? Using guns. Is that an inherently dangerous activity? Are guns inherently dangerous? Again, I would argue no. I mean, I grew up in Florida, like a lot of people have guns, but I don't know. It's an argument, I would say, but I don't think you would be held strictly liable for someone who's injured by a gun or strictly liable for someone who's injured by fireworks. You would be held strictly liable for, blasting or for destruction of a building. When you're like blowing something up. I don't know. Or you would be held strictly liable for like hazardous waste or chemicals, or like if you had a snake or a lion, like Mike Tyson or something. Okay, so what is vicarious liability? This is another one that a lot of people missed on essays, is vicarious liability. I think a lot of people miss supervening and intervening, events, and then a lot of people failed to discuss vicarious liability. This comes up a lot. Like anytime you see employer, employee, I would have even argued it in, yeah, they did in the Cutie's Cookies, right? Like whoever the employee was working for Cutie's Cookies, well, Cutie's Cookies could be held vicariously liable. In the other essay, there's also a vicarious liability, employer, employee, responding at superior, frolic versus detour, like that type of a discussion. When can you be held vicariously liable? I mean, when there's an employer, employee, when there's a master servant relationship, some sort of general contractor, subcontractor, potentially relationship. I mean, and there are certain circumstances where they're non-delegable duties, like a mall has a non-delegable duty to maintain a safe premises. Different types of negligent, I kind of mentioned that, negligent entrustment, negligent hiring, negligent design, negligent supervision can come up a lot, just like deviating from the standard of care. The attractive nuisance doctrine is like, if there's something that lures children onto the property, then those children will be treated as licensees or invitees instead of trespassers. Like there's a duty to make safe and to warn them because they're young and they were enticed to come onto the property. Survivorship versus wrongful death claim, like survivorship claim, are claims that the state could bring, on behalf of the deceased, like after they died. Like Tommy died, but Tommy had a major contract claim against Susie. Well, Tommy's estate could bring a survivorship claim against Susie. Wrongful death is actually a claim for how Tommy died, like medical malpractice or speeding and driving or something like that. And then medical malpractice claim in Florida, how do you bring it? You need to give them notice. They need to have, the case needs to be confirmed by an expert or some professional that there is a valid case, and then they get a choice between arbitration and mediation, and there's a limitation on damages. And then the limit to punitive damage in Florida is 3 times compensatory or $500,000, the greater of the two. So that's torts. I feel like torts is just about knowing all the different torts, writing about them all, and you'll do just fine. Con law is pretty tough, right? Because we have a lot of different questionnaires to talk about. So first 16 amendments. First Amendment is freedom of speech, freedom of religion, freedom of the press, freedom of petition, freedom of assembly, right? That's the First Amendment. All these fundamental rights, like freedom of speech and different types of words that are protected and words that are not protected, freedom of religion, free establishment and free exercise, These are all fundamental rights guaranteed by the First Amendment. Second and third, we can kind of skip. Fourth, fifth, and sixth, we'll talk about on our next, on the next questionnaire. But essentially, the Fourth Amendment is against unreasonable search and seizure. The Fifth Amendment is due process, takings clause. It's your right against self-incrimination, your right against double jeopardy, and your right to counsel before adversarial proceedings have begun, like your Miranda rights. And then the Sixth Amendment is your right to counsel after adversarial proceedings have begun, your confrontation clause, and your right to a speedy trial. Seventh Amendment is your right to a trial by jury for matters at law when there's money involved. Eighth Amendment is a right against cruel and unusual punishment. Says we can skip 9. 10th is like state sovereignty. This is something that we will talk about today. I see this in torts and in common law essays. Does anyone actually understand this concept that Florida has waived sovereign immunity for torts claims for planning decisions, but not operational decisions? Wait, did I say that backwards? I'm sorry. Florida has waived sovereign immunity for operational, but not planning decisions. Yeah, that's correct. So like, does anyone know what that really means? Operational versus planning? I actually, I wrote it in this Telegram chat. I don't know if people are in the Telegram chat.
So
But
it's like that you're gonna have a parade is operational, and then the other one is like where the parade's being actually held at.
yeah, exactly. And I shared this article, Understanding Planning versus Operational Decisions in Florida. I don't know if you guys are in this Telegram chat, but I encourage people to join it. And this is what it says right here. When it comes to suing the government for negligence in Florida, understand the difference between planning level and operational level decisions is crucial. Florida sovereign immunity protects government entities from being sued for certain actions, but it does not provide blanket protection. So in Florida, sovereign immunity is codified in section 7(6) whatever. It waives sovereign immunity in certain circumstances, allowing individuals to sue the government under certain conditions. Planning level decisions are those made by government entities involving policy making, discretion, and judgment. These decisions typically involve weighing various policy considerations, and because planning level decisions are integral to the government's ability to function and make policy, they're generally protected by sovereign immunity. So planning level decisions are protected, but operational level decisions, on the other hand, involve the implementation and execution of established policies. These decisions are typically more routine and involve less discretion. They are not protected by sovereign immunity, and government entities can be held liable for negligence in these cases. So, yeah, as the student was explaining, like planning would be like the state is involved in creating the parade and deciding, what it's going to celebrate, and they pick the floats and all that. Like they planned it out. Well, they're going to be protected. But if they're just operational, like they're like, oh, there's a parade, well, you can't go down this street because it's blocked off. And then by doing that, someone gets injured and they were negligent in that operational decision, then you could sue the state. So that's a pretty complex concept, but like, the more you know. Okay. So what was I talking about? Oh yeah, 10th Amendment. 10th Amendment is state sovereignty. An individual cannot sue the state except, in that situation, or if the individual is suing a government official for injunctive relief, like in their individual capacity. And then like police power, anti-commandeering clause. These are all things that come from the 10th Amendment. 11th Amendment is, well, actually, I kind of messed that up for y'all. 11th Amendment is sovereign immunity, and that's why I had that discussion about operational versus planning. 11th Amendment is that an individual cannot sue the state. The 10th Amendment is state sovereignty, meaning that the states govern themselves, they can't be commandeered upon, and they're preempted by the federal government. So in that layer of confusion, let me clarify that. The 10th Amendment is state sovereignty. States have police power and they operate as a state government. They can't be commandeered upon. And then 11th Amendment is sovereign immunity. And I was talking about 11th Amendment and how Florida operates and respects sovereign immunity, but Florida specifically has waived sovereign immunity for operational but not planning decisions in tort. So that's a little nugget that people missed on the essays compared to the model answer, and I just wanted to take the time to explain that today. And that's where it comes from. Like it stems from the idea of the federal 11th Amendment, and then Florida has its own sovereign immunity, codification. And then within that codification, they have the exception for operational decisions. All right, fair enough. Okay, and then like 14th Amendment is a big one. 13th Amendment is important too. It prohibits racial discrimination in private places. And then 14th Amendment we'll talk about a lot. 14th Amendment is like equal protection, the different scrutiny levels. Due process and equal protection and First Amendment, freedoms and fundamental rights, these are really important subjects on the Florida essays, especially federal. So what's subject to strict scrutiny in federal and Florida? So race, alienage, national origin, and does anyone know what's special about Florida?
Physical disability.
Right, disability, physical disability. So race, alienage, national origin, and disability. There's also like the camper mnemonic, contraception, abortion, marriage, procreation, education, and the right to raise your family. Again, abortion is I'm not sure it's still considered a fundamental right. It's kind of unclear right now. And then there's some other fundamental rights in Florida, like the right to vote, the right to work, the right to travel, access to courts, the right to bear arms, the right against self-incrimination, the right to privacy, anything, implicated under the Constitution. These are all fundamental rights in Florida. So like, be careful that if it's a fundamental right, it's gonna have to survive strict scrutiny. So strict scrutiny, intermediate scrutiny, and rational basis. We really need to know these definitions because it's pretty likely you'll have to write about these. Strict scrutiny means that the government has the burden of showing that the law is necessary to achieve a compelling government interest and is narrowly tailored, and there are alternative, well, no, it's narrowly tailored to that means, and there's no alternative way of accomplishing it. I would just say strict scrutiny means narrowly tailored, compelling government interests, right? The government has the burden of proof of showing that it's narrowly tailored to achieve a compelling government interest, and it's the least restrictive means of achieving that result. That's what I meant to say. So narrowly tailored to a compelling government interest is strict scrutiny. Intermediate scrutiny, and Stephanie on Thursday helped the class understand this, the eyes, intermediate scrutiny is an important government interest, right? It's substantially related to an important government interest. And that'd be like gender or illegitimacy. So strict scrutiny is necessary to achieve a compelling government interest, and intermediate scrutiny it's substantially related to an important government interest. The government will bear the burden of proof here. Intermediate scrutiny can also apply to like regulations of commercial speech, and we'll see a heightened form of intermediate scrutiny apply to time, place, and manner restrictions. So rational basis means the plaintiff has the burden of showing that, it's not reasonably related to a legitimate government purpose. The Lemon test, it's kind of been abrogated in the sense that we're going to now refer to historical case law, I guess, historical precepts in terms of separation of church and state. But typically, it's constitutionally problematic if the state is establishing or encroaching religion without a secular purpose. What's the difference between content-based and content-neutral restriction? So content-based is like, it's actually restricting the content of what's being said. Like you're not allowed to talk about, sports when you teach. That's crazy, right? Or content-based means you're not allowed to teach in a public park at 3 a.m. on a huge loudspeaker, right? That's a time, place, and manner restriction. So time, place, and manner are subject to a form of heightened form of intermediate scrutiny, and they're acceptable in many circumstances. Like you can say that a city can only have the strip clubs in one particular neighborhood. They're not saying that you can't have strip clubs, you can't express yourselves in that manner. We're just saying that the time, place, and manner would be restricted. Or like no one can have like there can't be a billboard that's super bright, right? There's a brightness restriction. That's going to be, a time, place, and manner, because it's like not what's being said, it's just like how it's being broadcast, and there's other reasons why. Okay, type of speech not protected in the First Amendment, so like words that are likely to incite imminent lawless activity, hate speech, obscenity, defamation, or false or misleading commercial speech. What are the requirements of enacting an ordinance or law in Florida? So, some Florida specifics here. There has to be an enactment clause, like being enacted in the state of Florida. It has to be related to the health, welfare, and morals of the people. It cannot be vague or overbroad, and most importantly, most heavily tested, it has to comply with the single subject rule, meaning that it can't be about, a curfew for juveniles and a law against taping bananas to the wall, right? If you guys know anything about art. That's like two subjects, right? So it's got to be single subject, clear title, enactment clause, related to the health, welfare, morals of the people, cannot be vague or overbroad. And then to actually become a law, it needs to be presented and signed by the governor. It needs to be bicameralism. It needs to be presented to both houses, read 3 times, and then actually signed by the governor. The governor cannot do a pocket veto in Florida. He has to, actually sign it. Okay. What are the requirements of enacting law in Florida, right? We got some of those main important things. The difference between chartered and unchartered counties in Florida. So chartered is going to be like a county like Dade County that has municipalities that can enact their own laws and ordinances. They can, they don't just have to follow the general laws of the state. What's the home rule power? The home rule power is the power of municipalities to enact laws and ordinances that do not conflict with the Florida Constitution. So that's the home rule power. And then vagueness means that it's unclear what's being punished. Vagueness and overbreath come up a lot in these essays. We'll see. We're about to jump into some essays. What's the difference between general law, special law, general law of local application? So general law applies to the whole state uniformly. Special law applies to only certain, counties or cities. And then a general law of local application applies based on population. A special law requires a referendum or a vote from the affected county, where general law of local application does not. Overbreath means that it's punishing or restricting more than intended. So like if you intend to, ban curse words in school and you say teachers cannot say any 4-letter words, that's very overbroad because, door is a 4-letter word. Okay, this one's super important, sunshine law. The sunshine law is a right of access. In Florida, the public have a right of access to all governmental proceedings. That includes, conversations, meetings, minutes, all these things. There is an exception if it's, 2 people, 2 representatives, and it's an unplanned meeting, and they're just, talking about things unrelated and they didn't plan on it. But the second they're like, oh, let's go over to the corner and talk about this new law, then it becomes a planned meeting and there should be a right of access. An argument to say why the sunshine law should not apply, the state will argue that Florida has a heightened right of privacy, but that argument should fail because the sunshine law provides this right of access. The homestead exemption, it protects half an acre inside a municipality and 160 acres outside a municipality, contiguous acres outside a municipality from for sale by outside creditor. We'll talk more about homestead exemption too in real property, so don't worry. Homestead exemption, sunshine law. I tell people who study for Florida, make sure you're really competent with the Florida specifics and distinctions, and those are two big ones: sunshine law and homestead exemption. What's required for procedural due process? Let's go with notice and hearing. The Kluger doctrine is a doctrine that allows for, let's say, restricting access to courts or, surviving strict scrutiny in the case of an overarching public necessity. So, maybe during COVID, they could restrict access to courts. If you guys remember that pandemic thing. A special legislative session is when the governor, calls a special legislative session and they have to talk about only why it was called for, unless they get over a 2/3 vote from both houses. But it's pretty much just a quick session to determine a really important something very important. Now, you say you know a lot of this? Of what? Oh, that wasn't. I'm sorry. I thought you wanted to explain something. I'm sorry. Never mind. Okay, let's just continue. Pretend I didn't say that. What's the difference between substantive due process and the equal protection clause? So substantive due process is when everyone's rights are being impacted, and equal protection is when a specific group is being targeted. What is privileges and immunities clause of Article 4? That means that they're discriminating against out-of-staters, right to travel, or like they're charging higher rates for commercial fishing licenses. And then Commerce Clause, that's about Congress, federal Congress. They can regulate the channels, instrumentalities, and economic activities of interstate commerce. A dormant Commerce Clause means that states cannot enact laws or legislation that would discriminate against interstate commerce or unduly burden interstate commerce. A possessory taking versus a regulatory taking. So possessory taking is like the government takes your home, or they force you to put a stop sign on your land. It's like a physical intrusion. Whereas a regulatory taking, and we'll see here the Penn Central multi-factor balancing test, means that a law or regulation by the government has essentially rendered your property economically unviable. You've been deprived of the investment back expectations, and there's been a sufficient diminution of value of your property. These are some factors that would call it a regulatory taking. Some regulation has deprived you of the value of your property. A non-conforming use versus a variance. So a non-conforming use means that you are grandfathered into doing something different than the applicable zoning laws. Like if I use this property as a barber shop, and then they zone it for residential, and I'm like, bro, I've been cutting hair since the 90s. And they're like, all right, you can continue to cut hair. That would be a non-conforming use. I'm grandfathered into that. A variance just means you apply to do something different. I move into a neighborhood, it's a residential neighborhood. I'm like, dude, these people have lots of hair. I could cut it. I need to open up a barber shop. Oh no, it's residential only. Can I apply for a variance? And they'll be like, no. And then they'll secretly be like, unless you pay us some money. No, I'm just kidding. But like, probably, right? That's how the real world works. But a variance means that you're allowed to do something different than what's zoned for. And then an amortization means, like, if you know about finance, it means you'll slowly pay off, or you'll slowly conform. It means like, okay, let's say you're granted a non-conforming use. You're allowed to open up a barber shop. Year 1, you can have 10 barbers. Year 5, you're only allowed 5 barbers. Year 7, you're supposed to have 2 barbers. And then year 10, no more barbers. You're going to slowly amortize and conform. This stuff's not tested that much, but the more you know. Speech and debate clause, I mean, it's kind of off the scope. It just means that legislators can't be held liable for their acts in the act of legislation, like defamation on the speech floor. Executive, legislative, and judicial branch. I think this is important to definitely talk about separation of powers, right? Like, there's encroachment, entanglement, entwinement, usurpation. These are different ways of saying the same thing, basically, where it's like certain acts are vested to the judiciary branch. They're the ones who, determine the constitutionality of laws. The legislative branch, they're the ones who make the laws. The executive branch, they're the ones who carry them out. Look for like, a statute that gives the mayor the authority to impose fines or punishments, right? That's kind of encroachment on the judiciary branch. So separation of powers is a often missed issue by students on con law. Commandeering clause, like the federal government cannot commandeer, they cannot force the states to enact legislation. It's really not tested that much on Florida essays. Full faith and credit, not tested too much. It just means like Florida has to accept the rulings of Georgia. A bill of attainder, these three could be tested. A bill of attainder means punishment without trial. It's unconstitutional. An ex post facto law means retroactively imposing punishment for behavior that was legal at the time. It's also unconstitutional. And then finally, impairment of contracts, also unconstitutional, means the government impairing a private or public contract. An example would be a curfew. If Miami Beach says during spring break, there's a curfew of 10 p.m. Well, there's an argument that, club, I don't even know if there's any clubs on the beach anymore. There used to be a lot, but whatever, Club Rocket Ship could potentially have a suit against the state because you're impeding their contracts with the DJ and the bartender or whatever it may be. Anything else people anticipate on Florida, not besides crim law, anything else? There are some things for sure. I really encourage everyone to read my book pretty carefully. What was someone gonna say?
I have a question,
Go ahead.
and it's just because I don't understand it though.
That's
So so the steps to become a bill, or for a bill to become a law, on Grossman, I know, sorry, but Grossman's video says that the governor can either sign it, or if he doesn't sign it within 7 days, or if he doesn't veto it within 7 days, then it becomes a law. But
Yeah.
then something about a pocket veto, and I just don't know it. So
No, that's true. No, don't discredit Jonathan Grossman. He's solid. It's like if you gotta learn calculus, you gotta learn how to add, subtract, multiply, and divide. And I think he's really solid. His videos for learning the fundamentals of the bar exam. So I encourage everyone to watch his videos for sure for the MBE and for Florida. They're really good. I just would caution you that like I don't really think it's a minimum competency test. I think it's a really tough test, and just learning the fundamentals doesn't work for everyone. So I try to encourage people to learn the devilish details. Now, this is a good example. You're talking about a pocket veto and the difference between Florida and the United States of America. Florida does not allow a pocket veto. So in that scenario where the governor did not sign it, it became law, right? That's what you're saying?
no, it says that if he doesn't veto it within 7 days, then it's a law.
Right, if he doesn't expressly veto it. So veto means that he has to actually veto it and say, I'm not, yeah. So if there's feedback, it's saying like, I'm doing this.
Nah, it's not if you have to the governor would have to affirmatively veto. Not signing is not a veto. He would have to affirmatively veto it. Leaving it unsigned means that it passed. There's a-
In federal law, there's something known as a pocket veto. A pocket veto is where the president just doesn't sign it. He doesn't affirmatively veto it. Veto means like rejecting it, right? I used to know this kid named Vito growing up. He's probably in jail right now. But veto means that you like expressly reject it. A pocket veto is you just don't sign it. So the president of the United States can do that, and it's a political move because the president could be like, if I veto this thing, then some of my people who send me money, because they're my people, they're gonna be pissed. But I could just not sign it. It won't pass. I won't put myself on record as being against it. And I'll just be like, oh, my bad, I forgot. It just slipped my mind. That's what a pocket veto is. Florida doesn't allow the governor to do that. So that's all that means, is that Florida, he has to actually veto it or else it becomes a law. Fair enough. I didn't know you were here, Vicky.
Yeah, thanks.
It's nice. Okay, where was I? Oh, I think I was pretty much done. Anything else? Any other questions? All right, sweet. There's just one more of these questionnaires, and I know you guys are like, oh, this is boring, I'm bored. But I'm telling you, I've been doing this for so long now. The questionnaires are the best. Like, if you could just master the questionnaires, you should do amazing on the essays. That's like a proven formula. That's like what I've been doing since the beginning. I mean, I now have given y'all so much material and so much things to help, but I'm telling you, when I first started teaching group courses, I used to go to the University of Miami Business School, go into one of the classrooms, and I'd have like 4 or 5 students, and I didn't even bring my computer. I would just go up there with a marker and the whiteboard, and I would just start writing things and start answering questions or whatever. And I'd be like, y'all need to take notes, right? And those students could pass this test. Now with all these like spoon-fed digital materials, I mean, there's really no reason we can't pass. But I'm telling you, the one thing that's been amazing has been the questionnaires. A lot of my students have come back to me and were just like, I just recited off my questionnaires and I crushed the essay. So that's the reason I'm going over this right now. All right, there's just one more questionnaire that we have to see. And then we'll call it, and then we'll look at some essays. Okay. So what's the Fourth Amendment? Fourth Amendment is right against unreasonable search and seizure, probable cause, warrants, things like that. Right to privacy, heightened right to privacy in Florida. The Fifth Amendment is due process, takings clause, but for criminal law, it's your right against self-incrimination, your right against double jeopardy, being charged with the same crime twice, and your Miranda rights, which definitely come up. Your Miranda rights are your right to counsel before adversarial proceedings have begun. And then the Sixth Amendment, as I said, is your right to counsel after adversarial proceedings have begun, your right confrontation clause, right to confront witnesses, and the right to a speedy trial. What's the standard for the right to privacy in Florida? It's heightened and express. So it's, very important in Florida that you have this right to privacy. This is a constitutional right. There could also be the tort of invasion of privacy, but that would be like a, Tommy snooping on Johnny. Fifth Amendment, or I'm sorry, a Fourth Amendment invasion of privacy would be like the government, wiretapping your phone calls. What's the privilege against self-incrimination? So that's a civil or criminal trial. You can plead the Fifth. Andrew, where were you on January 1st at 2 a.m.? I plead the Fifth, right? What is the exclusionary rule? So the exclusionary rule means that evidence that was obtained unlawfully, without a warrant, without probable cause, must be excluded at trial. It must be suppressed. It doesn't mean that the case needs to be dropped. It just means it's an evidentiary rule that evidence needs to be suppressed because it was obtained unlawfully. And then we can kind of jump to 12. The fruit of the poisonous tree doctrine follows the exclusionary rule. Any evidence that's excluded, any evidence that is found as a result of that unlawful evidence must also be excluded, considered fruit of the poisonous tree. The original, they did a search without a warrant. Well, okay, and they found a diary, right? Well, that diary needs to be excluded. Now, inside that diary, they found, all these scribblings that Tommy hid the stash, down at the beach. Well, then they go to the beach and they find the stash. Well, that stash is fruit of the poisonous tree, right? Because the stash was only found because of what was written in the diary, and the diary is only found because of an unlawful search. Exclusionary rule, fruit of the poisonous tree, Adam and Eve type stuff. Okay. What is a stop and frisk rule? So it's a pat down, right, for weapons, a Terry stop, same thing. Like, you're allowed to pat someone down, an officer, if you believe criminal activity is afoot, and the pat down is supposed to be for weapons. Now, while patting someone down, if you feel like a crunchy bag of granola and it's not granola, it's Tusi, I think it's called, Flacco, that's that, then you're allowed to continue. Now you have established probable cause, right? Like, you could have reasonable suspicion, or not even reasonable suspicion, just believe criminal activity is afoot. And then that could lead to reasonable suspicion or lead to probable cause. And that's, how it gets kind of sketchy in the court of law. All right, what about warrants? So warrants are solid. Warrant is like, it needs to be issued by a neutral magistrate. It needs to particularly describe, who's to be arrested or the items to be seized. There are exceptions to a warrant, and this is a good mnemonic to remember. It's spaces, SPACES, right? You could tell when I'm learning, I'm a big believer in writing things down. Even when I went to my little like get better and live your life, I was writing things down this morning because I think the lady even said, she was like, there's something tied to writing things down. It's scientific, brain to hand to learning. So I might write this mnemonic down, spaces. The S is for search incident to arrest, right? Like, you know, you're arrested, well, now they can search your cavity. Plain view doctrine, you know, I'm looking at you and you got freaking white powder all next to you, you know, I'm allowed to search that bag. The automobile exception, so you're allowed to do like a, you know, a sweep of the cavity of the automobile. You can't necessarily go into like a locked glove compartment, but you can, you know, the cop can flash around the automobile. C is consent. Like if Tommy's like, yeah, search my purse, bro, there's nothing in it. And then Tommy's got goodies in his purse, well, he consented to it. E is the exigent circumstances or like hot pursuit. You know, if the cops knock on the door and they hear like flushy, well, unless he ate like some bad Chinese food the night before, he's probably flushing down drugs and that would give him exigent circumstances to bust in the door. And then the other S would be like a stop and frisk or a Terry stop. So search incident to arrest, plain view doctrine, automobile exception, consent, exigent circumstances, and stop and frisk. That, I mean, that can help you power through one of these essays. Like, I really like the mnemonics. I didn't used to. I used to be like too bougie for mnemonics. I'm like, I don't need to learn mnemonics. I know the information. But then I'm like, the mnemonics help you on essays, especially because then you don't miss anything. You know, you're very sweeping and writing the more the merrier. So I've become a converter, a believer in mnemonics. What's an impermissibly suggestive lineup? So that means like, let's say, you know, the suspect, you know, he was like 7 feet tall. And then they do a lineup of a bunch of people who are like 5 feet tall and then 1 7-foot tall dude. That'd be pretty impermissible because it's suggestive, right? For the poisonous tree, we talked about plain view doctrine. Again, we talked about search into arrest, we talked about. And then the elements of robbery, conspiracy, burglary, murder, all these things could be discussed on an essay, you know, like even though I think they're more heavily tested on the MBE or maybe Florida Crim Pro, you know, if they say what crimes could Tommy be charged of, you're supposed to talk about them. This should be the easiest thing. The crimes aren't that different. Florida doesn't really distinguish between the theft crimes, so you could just, you know, you don't have to do like larceny, embezzlement, or whatever. It's just theft crimes. Robbery is just theft plus assault or battery. Conspiracy, you know, an agreement with another to commit a crime. Burglary is, you know, a trespass with the intent to commit a crime. And then murder, first, second, third degree murder in Florida. First degree murder is common law murder, you know, premeditated malice aforethought or violent felony. Second degree murder would be like depraved heart or intent to inflict great bodily harm type killing. And then third degree murders would be a murder that occurs during the commission of like a non-violent or non-enumerated felony. They don't really test that much, and they would test it on Crim Pro. Same with pretrial. This is like a Crim Pro essay. I just do this to show you how wide con law is. I mean, I think that was pretty good. We just did con law, and it was like, you see, we started with the First Amendment to the Constitution, and I ended up asking you what are the 3 different types of murder in Florida. Like, they really have a wide net for that. All right, that was I want to do that. I want to get everyone's, you know, ready back into the new year. I'm probably just going to continue con law workshop number 1. Let's just call it number 1 and 2. And let's look at some essays. But I really want to look specifically at like some Crim Pro essays. So con law essay number 1 and 2, 1217, and 1, 4. Cool. So you remember the first essay, we were like, oh, it's going to discuss these things. And it talked about the First Amendment. It talked about time, place, and manner, vagueness, overbreath, equal protection, prior restraints, right? On speech or regulations that prevent or burn speech from happening before it has occurred, they're generally disfavored. Some due process, takings clause, right, takings clause, and then Florida Sunshine Law, that was a pretty good one. And then this one was like, due process, rational basis review, fundamental rights, scrutiny levels. Florida Constitution prohibits setting excessive bail, so that's something we didn't mention, but good to know. And the judiciary is responsible for setting bond and making the determination whether someone charged with a criminal offense is entitled to bond pending trial. So ex post facto laws, separation of powers a little bit. Florida does not permit someone who's a convicted felon to serve in government office. To be eligible for government office, an individual must not have been convicted of a felony, must at least be 18 years old, and must be a resident of Florida and must not be incompetent. So all you felons out there, I don't think you're gonna be able to be a government office. And then July 19, Sunshine Law, privacy expressly protected, due process, procedural substantive, fundamental rights, strict scrutiny, equal protection, content neutral, impairment of contracts is pretty cool. And then they did talk about the Kluger test, right? The Kluger doctrine comes up. All right, cool. So they're like, those essays were pretty good. I want to definitely do one that's like crim pro-ish, and I kind of want to do one that's like pretty Florida one that's kind of like Florida specific in terms of like enacting a law and things like that. So just real quickly, I want to make sure I don't pick the ones that were assigned, anyone but the ones that were assigned.
I think February 2023 is not assigned, and I think that one might have a Concrim one in it.
Yeah, February 2023 definitely is Concrim. I know it. It's like the two dudes on the motorcycle and they killed the lady or something. Okay, so 17 and 18, we'll skip them. All right, and let's go to February 2023 and let's see about this lady and this darkness in her dark jacket. We could do this one too. July 2022, or did I say February 2023? What do you guys mean? Which one? David on his motorcycle and Jake, or these other people? Let's do David. Actually, I don't really care. What do you want to do, Natalie? July 2022 or February 2023?
July 2022.
All right, bet. Oh man, you picked a longer one. Okay, so let's do this. We'll do this one, and then hopefully we'll do a Florida essay one. Look, the Crim Pro ones are very similar. Fourth, Fifth, Sixth Amendment ones. I didn't even really used to even teach this subject, but they've been testing it so much lately that it's like I really got to teach it now. So you know, it's very familiar. If you ever watched like TV or went to law school or anything, it's the same conversation. Like, did they have a warrant? Does it need to be excluded? Were they read their Miranda rights? Like, do they have Sixth Amendment right to, like the same conversation. It should be solid. Okay. Okay, so this one is actually asking for crimes. That's interesting. Okay, discuss a memorandum that discusses the following. Assume Florida's criminal statutes are based on common law crimes. Discuss any crimes other than embezzlement, which with Kevin can be charged, and any defenses to those crimes. Discuss the legality of the search of Kevin's home and whether evidence obtained during the search would be admissible against Kevin. Discuss the admissibility of the statements Kevin made to Peters in the patrol car immediately after his arrest, and to Sarah and to Peters the next day on the phone. So you can already tell like what we're going to need to write about, right? Exclusionary rule, warrants, admissibility, that type of stuff. And then here, statements made. That sounds like Miranda rights. That sounds like, attorney, sounds like that. This crimes other than embezzlement is pretty rare, right? Like they rarely ask you to write about crimes, but that's why we do this, because they can ask you about anything. So this is going to be July 2022, we said? Question 1, yeah. July 2022, question 1. All right. So we're going to prepare a memorandum. So to, from, re, date, right? it doesn't really tell us who we're writing it to, so I just be like, to senior partner from examinee regarding Kevin. And then I like to do this. I don't know, like just pretty much anything. And then date would be today, 1/4/25. Don't put too much thought into this. Like this is just structuring it. So then I would say like this memorandum. I think we could just write memo. But they wrote memorandum. We'll discuss. And then that's it. It's gonna discuss these things, and we're just gonna kind of like piece them out. I mean, if I had more time, I would say like this memorandum will discuss like crimes K can be charged with and associated offenses, the legality of the searches and the admissibility of the evidence against K and the admissibility of K's statements. Patrol car and next day on the phone. All right, so we could change these headings as they go along, but right now we're just gonna do the old issue spotting thing. So we've really set this up super easy. There's 3 prongs. Each prong is gonna have issues, and within, we're just gonna identify the issues, and then we'll do the IRACs: issue, rule, analysis, opposing argument, conclusion. It's like very formulaic, but the hardest part is figuring out what the issues are. So let's see if we can figure some issues out. All right, Kevin, what are you up to? Kevin, a stockbroker. There we go. Had to pass a Series 7, Series 66. IBIS prep. We tutor for both of those exams. Embezzled money from his client's accounts. Kevin's supervisor, Mark, noticed unusual transactions in Kevin's accounts and began investigating them. So Kevin is a stockbroker. He embezzled money, and the supervisor figured him out. Fearing discovery, Kevin decided to burn down Mark's house to kill him. All right, what crime is that?
Attempted murder, or
Arson.
murder.
Yeah, arson, murder, attempted murder, right? Again, they don't really test crimes that much. This is like probably one of the only ones they ever do, but when they do, it's not gonna be that hard. Like if you don't know what crime burning down a house is, maybe this isn't the test for you, right? So we look at arson. I like that. That was obvious. And then yeah, attempted murder, right? Attempted murder. And then what's the thought about attempted murder and murder? Would they merge into each other?
Yeah.
Why would
Well, because if it was successful, you can't be charged for the.
what is it about
Mhm.
attempt? Attempt is what type of crime?
Specific intent.
An inchoate crime?
Yeah, an inchoate crime, exactly. Just maybe that's a buzzword we could figure out. Okay. Because if it's attempted murder and murder, you can be charged with them, not both of them. You can't be convicted of both of them. You can be charged with both of them, but not convicted of both of them. So he drove to a gas station 2 miles away from Mark's home and purchased some gasoline and matches. Kevin opened the door to the screened-in rear patio, entered, and set a patio chair ablaze. Immediate regret set in, and Kevin decided he no longer wanted to burn down Mark's house. Kevin put the flames out and left, grateful he had not damaged Mark's home. However, Kevin did not realize that the chair was still smoldering. It eventually caught fire, and the flames destroyed Mark's house. So, what is that called when you? Okay, I like that. You're someone saying overt action. But what's it called when you try to like stop it? Maybe like withdraw.
Yeah.
Withdrawal, yeah.
But it didn't seem like it was very successful.
Yeah.
Kevin thought that Mark was home when he lit the fire, but Mark was at the office working late. On the same night around 11:15, Mark returned home and saw Kevin's vehicle leaving his neighborhood. Mark found his house on fire and called the police. So he thought Mark was home, so he tried to kill him. Definitely attempted murder, right? He returned home and saw Kevin's vehicle leaving the neighborhood. Mark found his house on fire and called the police. Officer Peters arrived, and Mark told Peters about seeing Kevin leaving the neighborhood, the fire, and suspected embezzlement. Okay. Peters, I'm not gonna spend too much time on the murder, attempted murder, arson. Like, we'll read it, see what they have to say, but like, it's more rare that it's gonna be tested. I want to focus on the other pieces of this, but just know, yeah, bro could definitely go down for arson and attempted murder here, like for sure. All right. Peters investigated Kevin and obtained an arrest warrant based on probable cause. We like that for Kevin on embezzlement charges. Peters went to Kevin's house, knocked on the door, and was greeted outside by Kevin and his girlfriend, Sarah, who lived with Kevin. Man, Sarah, you got yourself in a bad situation. Kevin was handcuffed and arrested. Kevin told the officers, "You cannot come inside my house." Looking at Sarah, Kevin yelled, "Don't let them search the house." Okay, so Kevin's saying you cannot come inside, but it seems that they had an arrest warrant, right? They didn't have a search warrant, they had an arrest warrant. Do we see how that's important? Search warrant versus arrest warrant? Okay. Kevin was placed in a patrol vehicle and Peters approached him. Peters told Kevin he has the right to remain silent, that anything he said would be used against him, and then they had a right to an attorney present during questioning. So what's that called?
The Miranda warnings.
Yeah, he definitely had Miranda, right? So it seems like Miranda warnings were read. And then here it seems like arrest warrant versus search warrant and consent, right? Was there consent? I don't know. We'll see. I'm just like jotting things down. Okay. He was placed in the vehicle and Peters approached him. Peters told Kevin he had the right to remain silent, that anything he said would be used against him in court, and they had the right to have an attorney present. Peters then asked Kevin where he was on December 18th at 11 p.m. and Kevin replied, "It wasn't me. I put out the chair fire." Kevin was taken to jail. So that statement right there is an important statement, right?
Mm-hmm.
It wasn't me. I put out the chair fire.
Possibly voluntary.
Uh-huh. Voluntary. And it was after he was read his rights, right?
Mm-hmm.
Doesn't seem so problematic there. I mean, he had the right. He just fucking said it. What an idiot. Peters told, oh, I mean, Kevin, you know, my mom almost named me Kevin. My brother said, I don't care what you name him, I'm gonna call him Andrew. I'm so thankful for that. No offense if your name's Kevin, but like, I feel like I'd be a totally different person. So Peters told Sarah that Kevin was arrested for only for embezzlement, but that he believed Kevin also burned down someone's house. So Peter said that. Peters asked Sarah if he could search the house for evidence related to the embezzlement charge. Sarah agreed. So here you have consent of Sarah to search house, right? And there's some rules on that. We'll kind of see it. Like, see what's going on here. Sarah. As a result of the search, Peters seized incriminating documents related to the embezzlement charge. What does that make you think of?
Through the poisonous tree.
Yeah.
Exactly. Exclusionary rule for the poisonous tree. Like, whether or not those arguments are going to win, those words are going to be included on my essay, right? Like,
The question I was
Doesn't
gonna
that
have is
also
that
be plain view?
it could be.
plain view doctrine potentially.
The question I have is that like normally third-party consent is okay, but because Peters was there when when Kevin was yelling to his girlfriend, that's why it might not work, the argument with the government.
For
Right.
sure. For sure. There's gonna be arguments both ways. Okay. And again, all these essays are gonna be arguments both ways. If they weren't arguments both ways, then they wouldn't be essay prompts, right? They're not just gonna give you math problems where the answer is totally 7. They're gonna give you, it depends. That's why we're lawyers. Okay, Sarah agreed. As a result of the search, Peters seized incriminating documents related to the embezzlement charge. That sounds like fruit of the poisonous tree. Sarah also agreed to assist Peters by making a recorded phone call to Kevin to elicit information about whether Kevin had burned down a house. What does that sound like?
Violation of the Sixth Amendment.
It sounds like a lot of things. What are they talking about? This phone call right here. What did someone say? Fourth Amendment, invasion of privacy. It almost sounds like maybe entrapment or something. I don't know if they're gonna use that word, but it seems like, I don't think that might succeed, but it does kind of seem like you're setting this guy up, right?
It is
Was
for
it a
Flo-
confession? Well, would it be like confession?
Sure.
for
Like-
for Florida, what's the rule for like recordings regarding like one or two-way conversations? Because if they're gonna recording, get a statement.
You gotta have consent, right? You gotta let them know it's being
Was it one
recorded.
or two-way? Because some states are one-way. I forget.
Two-way.
No, Florida's a two-way state, yeah.
Two-way state? Okay.
Yeah. Okay, Sarah also agreed to assist Peters by making a recorded phone call to Kevin to listen information about whether Kevin burned down the house. Okay. The next day, Kevin attended his first appearance for the embezzlement charge. So what does that mean? Attend his first appearance. It's Sixth Amendment, right? So there's definitely like somewhere in this essay, I'm gonna put this at the bottom. We're definitely gonna have to talk about Fourth, Fifth, and Sixth Amendment. They all come into play here for different reasons, like in every one of these essays. Fourth, because of the, your right to privacy. Fifth, because the Miranda rights, and then sixth, because now your right to counsel after adversarial proceedings have begun. So he was given his first appearance, where he's appointed. After Kevin left the courthouse, Peters had Sarah called Kevin on a recorded line. During the call, Sarah asked, "Did you burn down someone's house?" He admitted that he started to burn down the house, but quickly put out the fire. Sarah hung up the phone. So he had Peters. So Peters had Sarah call him. It seems like he should have had a counsel with him, right? It seems like this is an interrogation, right? There's definitely going to be something about custody and interrogation. Those are some buzzwords. Like, is this a custodial interrogation? Is this a Sixth Amendment interrogation? It seems like he does have a right to counsel here, because the recording is happening by the officer. I mean, the interrogation is happening by the officer, not really Sarah. He admitted he burned it down, but quickly put it out. Sarah hung up the phone. A few minutes later, Peters called Kevin back and told him about the previously recorded conversation. Peters then told Kevin, "It's all out there now, as you may as well confess to the embezzlement too." Kevin confessed and told Peters about the money he embezzled. So he had statements. When it comes to here, there's like two statements. Statements in the patrol. There's three statements. Statements in the patrol car. That's Fifth Amendment. And then statements made to Sarah and Peters are Sixth Amendment. But remember, there's two statements. There's statements made to Sarah, and then there's statements made to Peters. There is a thought here about the inevitable discovery doctrine. Has anyone ever heard of that? I might think of that. Like, you can argue, like, even if something was found in, violation of the amendment of the Constitution and should be subject to the exclusionary rule, if it's determined that it would have been inevitably discovered anyway, then that evidence may still be admissible. So that's the inevitable discovery doctrine. Just because of a matter of time, and I do want to look at one more essay. Does anyone have any other issues that they may have seen spotted? I think there could be conspiracy here, maybe. Maybe not, though. Who was he conspiring with? Doesn't seem like anyone. I don't know. Let's check it out. We're here to learn. And remember how we learn. We copy and paste the rules of law, and that's what we're going to master memorize. So he could be potentially charged with burglary, arson, attempted murder. Okay, burglary. We didn't say that, but what would have tipped us off to burglary?
Wait, yeah, Grace said it.
Open the door to the screen. Oh yeah, Grace did say it. Thank you,
Yeah.
Grace. So we did say it. My bad. I just didn't write it down. And to be fair, I was like saying we're gonna go over these quickly because that's not tested so much. So what do they got for us? Burglary, specific intent. At common law, burglary was defined as the breaking, entering, dwelling of a nighttime with the intent to commit a felony therein. Today, modern courts have abolished the requirement the crime occurred at nighttime or the structure is a dwelling. It typically requires either unlawful breaking and entering, pretty much just trespass plus the intent to commit a felony. Breaking occurs when an individual uses any force to access an opening building. It does not occur when the door is wide open, but it will occur if any force is used to open the door. Further, burglary still occurs even if the defendant doesn't actually commit the felony. You only need the intent. So here's a big old burglary rule statement. We love that, right? I mean, again, actual crimes are not like tested that much, but they can be. And the last thing I want is for any of y'all to not be prepared. So this is a good essay for us to see. So here, it could definitely have been burglary. All right, what about arson? Arson is a general intent malice offense. At common law, arson was a reckless or intentional setting a flame with the dwelling of another. Today, arson is committed when an individual recklessly or intentionally sets fire to any building, not just homes. Though scorching of a building wouldn't constitute arson, charring will suffice. Right, just a nice little charring. For the record, Nat, this is you who chose this essay while we're doing the crimes. He intended to burn it down. It said attempt is an inchoate offense, right? And requires specific intent. I'll just take that. Attempt is an inchoate offense and requires specific intent, right? I mean, he definitely had this specific intent to do a lot of things here. Sorry, okay. So he's likely attempted arson or arson because the crimes merged. Now attempted murder. Attempt is an inchoate offense. To be guilty of attempt, they must commit a substantial step towards committing the crime. At common law, murder is the unlawful killing of another with malice of forethought. It could be committed through intent to commit great bodily harm, enumerated felony, in connection with drug trafficking, or depraved heart murder. And then there's actual and proximate causation. So here we're talking about attempted murder. Do you see how it's weird? Like, you wouldn't think that this would be a con law essay, but like, Florida merges all these things together. Get it? Merging. Here, attempted murder, right? He's probably going down for attempted murder, right? Like, this was a whole page and a half about burglary, arson, attempted murder. I mean, he did a lot of bad stuff, but this is what's more commonly tested, is what we're about to see here. Okay. Both the Fourth Amendment, the U.S. Constitution, and Florida's Constitution, which mirrors the Fourth Amendment, prohibit unreasonable searches and seizures of individual persons, houses, papers, and effects without a warrant issued with probable cause, absent applicable exception. Warrantless searches of a home are presumably unlawful. Fourth Amendment protection is especially strong in constitutionally protected areas like the home. Law enforcement is protected from unreasonable searches in the curtilage of the home or inside it. Exceptions include exigent circumstances, emergency aid to an individual inside the home, prohibiting an individual inside from destroying transitory evidence, searches incident to lawful arrest, or consent searches. That's what I kind of use spaces for. Consent may be given to search a home by the person who owns the home or lives in the home or is old enough to consent, and anyone who has apparent authority, meaning the officer reasonably believes that the individual can grant them authority to search the house. If one resident rejects consent, an officer may not search the home at any time. However, if officers arrest the individual for other reasons and return to the house and gain consent from another occupant, they may search the home with the individual's consent. So that's a nice long rule statement. Like, you see, this person really did really great with the rule statements. Like, the issue is whether the search is legal. Here's the rule. And then they're going back and forth about they likely conducted a lawful search because they came back, the girl gave consent, it was limited. They were permitted to find anything and they probably found it. Fair enough. All right, let's go to the admissibility of the statements. The federal, you see how I told you, it's like this one, you're going to have to talk about 4th, 5th, and 6th Amendment, and they did a really, good job of it. The federal 5th Amendment, good old 5A, and Florida constitutions provide a prophylactic. What? I've never seen that word used in this. Is that cool? You guys like that word right there? A prophylactic. You don't like that? Who? What is it? Who wrote this? Okay. The 5th Amendment, Florida Constitution provide a prophylactic. I'm sorry, I'm stuck on this. Prophylactic? Okay, it's supposed to be protective. I was gonna say there's no way this is the word. Something that prevents or protects. Yeah. Okay. It is prophylactic. That does make sense. Wow. All right. Florida Constitution provide a prophylactic, that's the word of the day, measure meant to prohibit officers from coercing defendants into making incriminating statements through a doctrine called Miranda. Let's get it. Miranda only applies to government action. Miranda applies to statements made under custodial interrogation. I told you those are keywords. A statement made by a defendant after he is placed under custodial interrogation will be admissible unless he has provided Miranda warnings, which include the defendant has a right to remain silent. Anything he says will and can be used against him, and he has a right to an attorney. If he cannot afford an attorney, one will be appointed for him. Custody, right? They're going to define custody and interrogation. I really like this. Custody means a reasonable person wouldn't feel free to leave, and conditions are similar to a traditional arrest. These warnings don't need to be verbatim, but should at least give the gist. Interrogation means statement by law enforcement that they should know are likely to elicit an incriminating response. Any statement obtained in violation of Miranda will be inadmissible. Miranda does not apply to spontaneous statements. The right to remain silent, the right to counsel must be invoked. If invoked, the right to remain silent must be scrupulously honored, and the right to counsel must be provided before the defendant makes any statements. All right, this guy was like an English major for sure. Or girl, or non-binary. This person, I think we can go person, definitely a person, a prophylactic person. That's some good wordage. Okay. Sorry. Okay, a lot about the Fifth Amendment. Here, Kevin was in the control car. He was likely in custody. He was subject to interrogation. He received Miranda. Thus, he didn't receive Miranda rights. It could be probably admissible. They would likely say statements with a response to his question, a spontaneous statement. It was made in response to a question. We might probably make the statement not spontaneous would be inadmissible because it was a custodial interrogation. He should have received Miranda rights. He received the first three of the warnings, but was not told that if he couldn't afford an attorney, that one would be provided for him. Okay, fair enough. Getting into semantics. I mean, he did say that you only need to receive the gist of it, but that is true. So, fair enough point that maybe it wasn't sufficient Miranda warnings. Like that's why officers really need to read them like 21 Jump Street style. All right, and then look, I told you it's gonna be Fourth, Fifth, and Sixth Amendment. All these essays require you to do this, to tell them what's going down on the Fourth, Fifth, and Sixth Amendment. The Sixth Amendment right to counsel attaches when the defendant is formally charged and prohibits officers from communicating with the defendant without counsel present. The Sixth Amendment is offense specific. Defendant has a right to have counsel present at every critical stage of the case. Once the defendant is appointed attorney, officers and agents of the officer are prohibited from communicating with the defendant to elicit incriminating responses from him. The right to counsel must be invoked by the defendant and may be waived if the defendant communicates. The defendant had counsel and could have been said to invoke the right to counsel. So that's Sixth Amendment. Let's see what they're talking about with Agent Sarah. Here she was an agent. She agreed. She, was doing interrogation. However, he hadn't been charged. He'd only been charged with embezzlement, not arson. So the Sixth Amendment doesn't apply. He may argue that the Fifth Amendment protects him, but the defendants must unambiguously and unequivocally invoke that right to remain silent. Further, the Fifth Amendment only applies to government action because Sarah was being used as an agent. Government action may be met. However, the phone call wouldn't qualify as a custodial interrogation because the custodial aspect wasn't met. A reasonable person would be feel free to leave. Thus, the phone call was likely admissible. If the defendant invoked his right to counsel, the statements may be inadmissible, though a phone call with the officer would probably be admissible in the Sixth Amendment. It could qualify as a coerced statement, which is unadmissible. Statements must be voluntary to be admissible, but statements where the officer uses undue coercion on the defendant may prevent that statement from being admissible. I mean, I think that was like a good argument. Coercion. Oh, shit. Yeah, statements, it could be coerced. I mean, again, you see, these are essays that are just written by people in the nick of time. Like, they're not perfect, and there's arguments that go both ways, but they really got down to the main pieces that I told you they would write about, which were Fourth, Fifth, and Sixth Amendment. All right, I really appreciate everyone. I'm gonna, just because I'm committed to thoroughness, I'm gonna look at one more essay that might just tie some pieces together. That one was really good. When it comes to Fourth, Fifth, Sixth Amendment, those are the conversations you want to be familiar with. The exclusionary rule, fruit of the poisonous tree doctrine, interrogation, custody, Miranda rights, exceptions to the need for a warrant. Like those are all things that are pretty heavily tested. And I think that they're not so difficult, right? We should be familiar with them. I just want to look at one more essay that's a little bit more Florida con law specific. I don't really have one in mind. Which ones did I put? Did I assign you guys? 2017 and 2018. Okay, good. Here we go. This one says Florida con law. We didn't look at this one, did we? I don't think so. Okay. So anyway, this one's a terrible essay. If you got this essay in 2013, you should have like not been happy. This was a tough essay. But let's see what the model answer really addressed. Exactly. It's a great one to do. I'm sorry to keep you guys an extra like 10 or so minutes, but it's very important. So just bear with me. All right, as a preliminary matter, the governor has the authority, so let's just put this one here. This is July 2013, question 2. July 2013, question 2. And you guys can, obviously go back and revisit, but I just want to get some of these key points down. As a preliminary matter, the governor has the authority under the Florida Constitution to call a special legislative session. Special legislative sessions must be limited in scope, and the absence of the requisite vote of the members of the House and Senate, 2/3 vote, no new members may be addressed during a special session other than those for which the special session was called. So, Nat, when I was teaching earlier, this is when you direct messaged me that you knew this stuff. Were you talking about this special legislative session?
Yeah, well, to be clear, I wasn't just being like, Andrew, I know everything. I
Yeah.
said, I actually know this, and I didn't know it last time. So
No, that's amazing. And you passed. You passed the UB like really well. But Florida's a little tougher, so I appreciate that you're not just coasting by and you're here and you're working hard. All right. So here there's some weird facts. When a bill is submitted to the governor for signature or veto, the governor has 7 days or 15 days if submitted at the end of the session to exercise his veto power. So that's what we talked about. And I'm glad you did ask that question, and that our resident con law expert, Vicky, was able to explain the importance that Florida does not have a pocket veto. So they have to actually veto it or else it's going to become a law. Where at federal law, they can exercise what's known as the pocket veto. All right, this is important right here. Formalities. Each law must comply with certain constitutional formalities in order to be valid. First, the act includes a short title that sufficiently describes the subject matter of the law. Second, there's an enacting clause. Finally, the purpose of the act was likely in accordance with the legislature's authority to pass laws for the general welfare, health, safety, and morals of the public, as the purpose of the bill deals with litigation efficiency and raising revenue. However, the act likely violates the single subject rule. I remember I told you guys this is like heavily tested in Florida, single subject rule. To comply with the Florida Constitution, a law must cover only one subject. Each component or aspect of a law must have some natural relation to an overall scheme. So single subject rule is part of constitutionalities of an act. And they said all the things we said: clear title, enactment clause, not vague or overbroad, related to the health, welfare, and morals of the people. And then to turn into a law, it would have to comply with bicameralism and be presented to the governor. So Section 1 indicates as a special law. A special law, unlike a general law, is a law that only applies to particular geographic areas in the state. Special laws are permitted so long as voters in the affected area are given notice of the proposed law and a referendum is held. Additionally, a special law, as well as a general law of local application, which does not require notice and referendum, but applies to certain areas based on classification schemes such as population, cannot cover certain subject matter that the Florida Constitution expressly prohibits. Ooh, I love this right here. Because some things like, I want to teach are written in my book, but like I just slips my mind. These are a great place to get it. Prohibited subject matter. Such prohibited subject matter includes taxation, elections, petite juries, conditions precedent to bring civil or criminal claims, venue rules, and rules of evidence. That's actually a really nice sentence right there. I'm obviously going to copy this whole thing, but if you could remember, those are prohibited by the Florida Constitution. They can't be general or special laws or general laws of local application. They have to be general laws to be those subject matters. They are prohibited subject matters for special laws or general laws of local application. And what are they? Like we said, taxation, elections, petite juries, conditioned precedent to bring civil or criminal claims, venue rules, and rules of evidence. I've seen this come up as like, this might be a conditioned precedent to bring civil or criminal claims, which therefore would be invalidated. Like that's a really difficult concept. If you don't understand it, it's not like you're going to fail the Florida bar exam, but like I always say, the more you know. All right. Here, it's a special law. There's no notice that there was a referendum, but we would make an assumption. Section 2 suffers from several constitutional infirmities, including an improper infringement on the fundamental right of access to courts. Access to courts comes up a good amount. Equal protection comes up on like every essay, and prohibiting subject matter law. So let's talk about access to courts. The Florida Constitution provides that the right to access courts will not be infringed upon and that justice will be administered without sale, denial, or delay. When the legislator significantly burdens this right in a manner that amounts to abolishing a cause of action, a reasonable alternative must be provided unless the legislator can make the difficult showing that a public necessity exists and that no alternative can reasonably be established under the Kluger Doctrine. really good stuff, really good stuff. Really good stuff. Here, it seems like there's a problem with the access to courts issue. Prohibited subject matter, requiring residents of one county to post bond before bringing a civil malpractice claim violates this prohibition, right? That's how they saw that it was a condition precedent. This is a really good essay to learn from. I like this one. And then equal protection comes up a lot. Florida Constitution prohibits discrimination against individuals based on race, alienage, gender, religion, and physical handicap. Any discrimination on these bases will be subject to strict scrutiny. I mean, gender is going to be intermediate, but fair enough. And wealth is not a suspect class. Instead, it's going to be rational basis. The Supreme Court of the United States, as well as Florida, have recognized that when discrimination against the poor involves a fundamental right, heightened scrutiny should be applied. Okay, fair enough. Scrutiny levels, right? I think like that's major. You got to be able to talk about scrutiny levels and you know, compelling for strict, important for intermediate, and legitimate or rational for rational basis. So here they're saying rational basis isn't even met, la di da di da, whatever. Due process, I'm telling you, equal protection, due process, almost every essay. Vagueness, overbreadth, they come up a lot. First Amendment concerns come up a lot. Like con law is a lot, but like it gets very repetitive. And I really encourage everyone to do exactly what I'm doing here today, which is just go over previous essays, tease out the rules of law, and commit them to memory. And if you can do that, you're gonna have a good experience on the exam. Okay, so Florida Constitution expressly protects the right of both procedural and substantive due process. Substantive due process involves the protection of fundamental rights, and procedural due process protects against unconstitutional deprivations of protected interest without notice and hearing, and protects the right to a fair trial. Infringements of either aspect of due process implicate strict scrutiny review, right? Like I really like these essays because, you know, you read from outlines, you read from textbooks, and it's like, they're so long and detailed. When you read someone who actually wrote an essay and the Florida bar determined it was the best written essay, it gives you some great language that you can incorporate yourself. So Section 3 is also constitutionally invalid because it involves taxation, which is prohibited. The state is not empowered to collect ad valorem taxes. Did you all know that? That only counties can collect taxes. Like, you know, my property taxes, I have to pay to Dade County. So the state is not empowered to collect ad valorem taxes. Right. And ad valorem taxes are imposed on real property, not personal property such as motor vehicles. So that's, you know, that's not important, but it's like there's little nuances to these questions, to these test questions. That one was like, oh, and now the state is trying to collect ad valorem taxes on everyone's motor vehicles. And it's like, hold up, that's wrong for two reasons. It's wrong because counties collect property taxes, not the state, and it's wrong because ad valorem taxes are for property, not motor vehicles. So like little things that, you know, you can take note of. All right, and then after that, it's just ethical issues. I'm not really going to include the ethical issues here because this is not ethics today. But you know, this is a really great outline that we made. It's already in the classroom. And you can access this. We did a lot of essays on here for con law, more than any other subject. I think we did like 5 or 6. And it's, you know, the same type of stuff: due process, equal protection, First Amendment, 4th, 5th, 6th Amendment. And, you know, there's little things that come up that we didn't talk about on any of these workshops, but I would encourage you to go back through the actual model answers and leave no stone unturned, and just, you know, don't just count on the work we do in the workshops, but utilize the strategies in your own study. And I think that'll work out well for everyone. So I'm going to go ahead and stop this recording.